Welcome, welcome. Oh, sorry. Welcome, welcome. Good morning. Just to let you know that the meeting is being recorded, as you might have heard right now. And I just want to thank you. Thank you for taking time out of your morning to come and be a part of this. And we have some wonderful speakers with some great information. And we just really hope that you walk away with something new today, something useful, something that we can carry on to create change. So today we have Carmen Romero. And Carmen was a career public defender for 25 years before reentering as a senior defense attorney in 2014. She then worked with Central California Legal Services with the health team from 2015 to 2018 before attempting to retire again. She returned to Fresno County Public Defender in 2018 to work in the Clean Slate program, where she says this is the best job she's ever had. Amen to that. And so go ahead, Carmen. Thank you. Thank you so much for being willing to talk today and share your wisdom with us.
Well, thank you for having me. There's actually two of us that are going to be.
Oh, okay. I'm sorry. Go ahead. If you want to introduce
Farida Perez is here, and she's going to be talking about workers' rights and employment issues that arise out of criminal history and incarceration. So Farida Perez is with the ACLU. And so she also has some wonderful information for us and is a great resource to us in the Central Valley. So I'm glad she's here with us today.
Perfect. Thank you so much, Farida.
So I will be talking about criminal history, clearing criminal history, and to our Christian. I don't see the slides. Thank you. Okay, so I'm going to be talking about clearing your criminal history, what that involves, what it means in California, and then Farida will follow up with talking about an impact on employment. So next slide, please. So this is an overview of what I hope to cover this morning. Before we get much further, if you could reserve your questions till the end, we're going to leave some significant time at the end of the presentation so that we can answer your questions, okay? So this is the overview. We're going to be talking about the different means of clearing your criminal history, the benefits of clearing your criminal history, and what clearing your history will not accomplish. Next slide, please. So in California, unfortunately, there is no way to completely erase the fact that you had a case or cases, that you were arrested and charged with the matter in court. California doesn't afford that opportunity. Other states do, and hopefully at some point in the future, California will also decide that it's not necessary to continue to broadcast the fact that a person has had criminal convictions in their past. The record clearing that is available also will not prevent, in most circumstances, will not prevent the case from being used against you in certain circumstances, and we'll discuss what those circumstances are. And in most situations, it will not restore gun rights, and it will certainly not be able to help you with any restrictions on gun rights as a result of federal laws. This is just the relief that we'll be discussing this morning is available only with regard to California state convictions. We do not discuss this morning federal expungement, although you should know that federal expungement for all intents and purposes does not exist. So we don't do it, and it's very difficult even for those folks who do afford that service to actually get federal convictions expunged. And it will not remove the obligation of having to register as a 290, as a sex offender under Penal Code Section 290. So those are the limitations of what we are able to do for folks. Next slide. So there's different ways of limiting the impact of criminal history on a person. One is if there have been felony convictions, whether or not the felony is eligible to be reduced to a misdemeanor. That often relieves a lot of issues for folks because of felony convictions. Now they're misdemeanor convictions, and those in some circumstances are considered less onerous, less serious than a felony conviction. There's also dismissals, and we're probably going to be spending most of our time talking about dismissals or under the expungement statute in California. And there's also effective 2018, the possibility of having a criminal case sealed completely. So that is another means of limiting what actually shows up in your criminal history. Next slide, please. So how do you reduce a felony to a misdemeanor? Well, the felony has to qualify, and the felony has to be what's called a wobbler. A wobbler is the kind of felony where at the time of sentencing, the court has the opportunity to either treat the matter as a misdemeanor and declare the charge a misdemeanor, or to proceed as though it was an actual felony. So if in that particular charge, that opportunity is afforded to the court, that is considered a wobbler. So the court has, again, the option to treat it as a misdemeanor or to treat it as a felony. So if it's a felony conviction on a wobbler charge, you can file what's called a motion pursuant to Penal Code Section 17B. And what you're asking the court to consider is whether it's in the interest of justice, your felony conviction should be reduced to a misdemeanor. So the kinds of things that the court considers is certainly your behavior while on felony probation or since the felony conviction. What's the reason that you need this reduced? So evidence of the hardship that it's causing you. So denial of employment, denial of housing, that sort of thing. Are the sorts of compelling reasons that the court looks for in terms of deciding whether to reduce a felony to a misdemeanor. Now, here's the downside. Even though a 17B motion might be granted, it's still considered a felony under federal gun laws. And there's nothing we can do about that. It's still considered a strike unless the reduction occurred at the time of sentencing. So if you're asking for that reduction after sentencing, after you've done your probation, then it's not going to prevent it from being used as a strike in future prosecutions. It is still considered a felony for certain state regulated professions. And there's no relief from sex registration requirements. So those are the limitations on a 17B motion, but it certainly is a misdemeanor. And so that helps in many instances in, as I said before, obtaining housing, educational opportunities, employment, and maybe even financial aid for education. The other way you can have a felony reduced to a misdemeanor is under Proposition 47. Proposition 47 changed many felonies and reduced them to misdemeanors. And so if you were convicted of a felony that falls under Proposition 47, you can file a request with the court and ask that the court now reduce the felony to a misdemeanor and resentence you so that it is now a misdemeanor for all purposes. It doesn't matter whether you went to prison on a qualifying felony. Under Proposition 47, you can still petition the court to have it reduced. The other way that you can have a felony reduced to a misdemeanor is under Proposition 64. That's the marijuana proposition. And that also changed many felonies to misdemeanors. It also changed many misdemeanors to infractions and did away completely with other sorts of crimes related to the use, possession, or movement of marijuana. So those are the ways that we have of helping you have a felony reduced to a misdemeanor. Next slide, please. So expungement. So what's an expungement? So this is very misleading, the term, if you hear it without out of context, it makes it sound like somebody's actually wiping your record clean when an expungement is granted, but that's not what it is. An expungement is a dismissal of a previous conviction. And what it does is it doesn't take the case out of your criminal record. It's still going to show as a conviction at some point, but it's if the expungement is granted, in addition to the conviction, it will also show that the court set aside that conviction and dismiss the matter. So for most purposes, it will no longer be a conviction. Now, depending on the charge and your performance on probation, it can be mandatory or it can be discretionary. And mandatory means that the court must grant it. And discretionary means that the court can deny. Now, if you've done an excellent job while you were on probation, you had no violations, you paid your fines, then in most instances, the court will have to grant your request to have the matter expunged. Now, on some cases, some matters, even if you did well, even if you paid all of your fines and fees, it still is discretionary. And examples of that are the driving under the influence convictions. Those, every time anything related to alcohol and driving, the court will have discretion to say no to you, even though you did well, even though you haven't had any subsequent convictions, alcohol related or otherwise, and even though you've paid your fines. Next slide. Mandatory relief, the court wants to know whether you're currently on a felony probation or misdemeanor probation. If you're off of probation for either a felony or a misdemeanor, and you're no longer serving a sentence or on probation or parole at this point, you're not currently facing charges, you don't have any open matters anywhere, anything in bench warrant status, anything in arrest warrant status, matters that are just sitting there not having been resolved, and you have completed the terms and conditions of probation. Now, so if you're not on probation, you're not on parole, you are not currently serving a sentence, you're not currently facing charges, and you have completed the terms and conditions of probation, including payment of fines and fees, then the relief that you're asking for would be mandatory. The court has to grant it to you. Next slide, please. It's discretionary. Okay, so discretionary is when the court has, can deny you. And so when it's discretionary, it's because in most situations, it's because you had violations of probation. During the term of your probation, and it can be formal probation or conditional sentence or informal probation, any of those, any form of probation, if during the time that you were on probation, you had a violation of probation, and violations of probation could include situations where there was never a declaration of a violation of probation, but while you were on probation, you committed a new offense. So the courts, because they have your entire criminal history in front of them by the time you're asking them to expunge a specific case, will also know whether or not you suffered subsequent arrest while you were on probation. And so that then becomes a discretionary grant of the expungement. Also, if you have outstanding fines and fees, discretion to deny you, and in at least in Fresno County, some other counties no, but in Fresno County and in other counties, if you have outstanding fines and fees, it's an automatic denial. The court would automatically deny your petition for a dismissal. And as I said earlier, certain charges are always discretionary, even though you've done well, even though you paid your fines and fees, and even though you may not have had any subsequent convictions, any convictions after the case that you're asking to have dismissed. So example, again, is driving under the influence and certain sex crimes, most of those related to crimes against children. Next slide, please. All right, so you're not eligible for expungement if you were sentenced to prison on certain charges. And most of those charges have to do with violent or serious or violent crimes. where you were sent to prison, domestic violence convictions where you were sent to prison, DUI convictions, felony DUIs where you were sent to prison, those kinds of cases. And this is a limited list. I'm not suggesting that that's all of the crimes that would make you ineligible for expungement, but those are examples of charges, convictions that would not be eligible for expungement. And if you were specifically convicted of violation of Vehicle Code 42002.1, then you're not eligible. That conviction would not be eligible for expungement, excuse me. And most folks, that really applies to some truck drivers, not most folks don't even know what that was. I didn't know what that was until I started doing this work. And again, certain sexual crimes against children are not eligible for expungement, and no vehicle code infractions are eligible. Penal code infractions are eligible. Now, let me explain the difference between what is an infraction. Infraction is a charge where the worst that the court can do to you is charge you a fine. And so they cannot jail you for violating an infraction. All they can do is charge you money. So misdemeanors, the most that they can do is put you in jail for up to a year, no more than a year. And felonies, of course, they can put you in jail, possibly prison, for a year, 2 years, 3 years, whatever it is that the statute allows. That's the consequence. You would go to prison and be incarcerated for longer than a year. So those are the differences between felonies, misdemeanors, and infractions. And again, vehicle code infractions are never eligible for expungement. Next slide. Okay, so these are the different sections under the, so the statute that covers expungements is Penal Code Section 1203.4, and we say FSEC, that means everything that follows after that. All of those are different categories that where you might qualify for expungement depending on the crime and depending on the sentence. So for most folks, it's 1203.4, and that's because you were granted probation on a felony or a misdemeanor, okay? And your charge is eligible, so it's not a sex crime of some kind, usually related to children. And if you had, again, if you had problems while on probation, or the charge is one where the relief is not mandatory, then the court does have discretion to deny you. So we'll talk about what kind of additional evidence you need to show or to present to the court to justify having this granted, even though you were not successful, because it is in the interest of justice. It's the right thing to do. Next section. So 1203.4A, you were convicted of usually a misdemeanor, always a misdemeanor, I'm sorry, and you were denied probation. If you're convicted of a felony and you're denied probation, that means you're going to prison or you have gone to prison. So this 1203.4A only applies to misdemeanor convictions where you were denied probation. It also applies to convictions for infraction, not under the vehicle code. So an example of a penal code infraction is a disturbing the peace, which can be charged as either a misdemeanor or an infraction. If your disturbing the peace misdemeanor was reduced to an infraction, then that is eligible for expungement. The relief under 1203.4A is always discretionary, and you will need to present additional evidence of to justify that it's in the interest of justice to grant you this relief. Next slide. 1203.49, this is a very specific section, and it applies only to people who were convicted under Penal Code Section 647B, which is the solicitation statute. And so if you were convicted of that, and you can establish by clear and convincing evidence that the conviction was a result of you being a victim of human trafficking, then this would result in your charge being expunged. But you know, clear and convincing evidence is very, very difficult. And so if that happens, then we really need to work very hard to convince the court that, in fact, you were a victim of human trafficking, and the evidence that's required for that is very specific. And the relief is discretionary. So if the court doesn't buy your explanation that you were the victim and that's why you committed this offense, the 647B, or the evidence that we present is not, the court doesn't find it clear and convincing, that then the relief would be denied. However, you might still be eligible, you probably would still be eligible for expungement under the 1203.4, the very first category that we discussed. Next section. 1203.41. So you were convicted of a felony, and instead of sending you to prison, to CDCR, you were granted local prison, that's prison in the county jail, and you were granted, you were either ordered to mandatory supervision or not, either one, okay? And you're not currently being charged with a crime, and it's been more than a year since you completed your mandatory supervision after being released from custody, or it's been more than 2 years since you completed your sentence and were not ordered mandatory supervision. And again, the relief is discretionary, so interest of justice would have to be supported. Next slide. All right, so 1203.42 is where you were sentenced to prison on a charge, where today you would have been sentenced to local jail or local prison, okay? So that is those crimes that I talked about under Proposition 47 this is what we're talking about now. So at some point in the past, you were sentenced to prison on a charge where today you would not have been sentenced to local jail. So crimes prior to December, I think it was September of 2011 would qualify, even if you went to prison. The other thing that you have to establish is you're not currently under any kind of supervision. You're not currently serving a sentence, or you're not on probation, and you're not being charged with a crime. And more than 2 years have passed since completing your prison sentence. And again, because it's discretionary, that's established that it's in the interest of justice to grant you the relief. The next slide. 1203.43. Those are for folks who were given diversion. Okay, so diversion, there's a few ways you would have been given diversion. There were some theft-related crimes that the court will send you to diversion. And there's also some drug offenses where you were ordered to do deferred entry of judgment. So you were given some form of deferred entry of judgment, and then the charges were dismissed pursuant to Penal Code 1000.3. So there is no discretion here. If this is what happened, you completed your deferred entry of judgment and the court has dismissed your case, then there is no discretion. The court has to seal your record. It's actually a sealing of your record, which is different from just an outright dismissal. It's already been dismissed. So the court is taking one further step and saying, now we're going to seal it. Okay, next slide. So what's in the interest of justice? Why is it the right thing to do? What you're telling the court is, you are such a different person here and now than you were at the point in time that you committed the offenses, even if you had violations of probation, that it is the right thing to do. If you had a drug problem, you have now been rehabilitated. So you have evidence of treatment, you're attending AA or NA or have in the past. Maybe you yourself are involved with AA or NA, you are a sponsor, you are a substance abuse counselor. I mean, anything that you've done to address your substance abuse and show the court that you are now sober and no longer using, that is the kind of evidence that we would want. And so, proof of employment, proof of rehabilitation, including letters from folks who are involved maybe with your with the sober community, or who know that you are involved and have watched you and know that you're actually sober. That would be the kind of thing that we would want to present if your drugs were the issue behind you having been committing crimes in the past. Also, if you have, subsequent to your convictions, educated, gone back to school. You now have maybe, maybe you didn't have a high school diploma and now you have either a GED or a diploma. Maybe you had that, or even if you earned your GED or diploma and then decided to go to college, you decided to get a master, whatever it is that you've done, trade, you've done some vocational training, whatever it is you've done to improve yourself in terms of education, we would want proof of that. Employment history, what it is that you've been doing to support yourself, to support your family, what kinds of jobs have you held, maybe you've been working with a company and you've been advancing within the company, and now you're at probably as far as you can go, and the company is telling you, we want to advance you even further, we want to put you in this position here, but you have to be able to pass a background check. If that's what your employer is telling you, that's huge. The court needs to know that. And so we would want to document that were it not for these convictions, you would be offered higher employment, more steady employment, better benefits, whatever it is that the company is suggesting you would be eligible for without these convictions. If you have been participating in volunteer activities in the community, maybe you're a member of some organization in the community, maybe you volunteer at the food bank, maybe you participate in church activities, where there your food drives, backpack drives, excuse me, whatever it is that you're doing in the community as a volunteer, if we can document that. And documentation can be letters from people that you work with in those volunteer activities. It can, maybe you got recognition for your activities, and maybe you have a certificate of some kind where somebody said to you, thank you for participating in this, and now you have that documented. The other way that you can document that is, some folks, they actually, they get publicity. Maybe there was an article in the newspaper, maybe Facebook, somewhere on Facebook, somebody said this organization is out here, and here is this person specifically who is now participating in this activity. Whatever it is that you can have, that we can use, is something that we want you to tell us about, so maybe we can help you get a hold of it. Involvement in church or a place of worship, some sort of spiritual involvement somewhere. Maybe you've been attending the same church for 5 or 6, 10 years, whatever it is, and they know you there. They know you there because maybe you help transport folks to the services. Maybe you're one of those people that is raising monies for particular activities within the church. Maybe you're helping build the church. Maybe you're raising monies to help build the church. Maybe you are the Sunday school teacher. Maybe you're participating in ministries from the church to others who are maybe facing the same sort of challenges that you were facing when you were first released from custody. Whatever it is that you're doing with your place of worship, and that would be great to document. So again, the specific kinds of documents are certificates of any kind that you've received in any situation, diplomas from your educational endeavors, awards that you've received, good work evaluations. If you're being evaluated at work and they give it to you in writing, that would be great. And letters of recommendation. Letters of recommendation from current or past employers, from people that you're working with in your volunteer activities, from teachers, mentors, counselors. Maybe you have a sponsor, maybe your sponsor wants to write a letter, from your deacon at church, your pastor at church, your good buddy, your good friend, your best friend who's known you, for years and years and has watched you grow and watched you change over the years and can speak to that. That kind of letter would be great. Family recommendations are okay. They're probably the least favored by the court because, family has a natural bias. You're not going to submit a letter on behalf of your relative that might be negative. But if that's all you have, then heck yeah, we'll go with it. We'll try to figure out who in your family can write you the best letter and what that family member wants to be able to talk about in their letter of recommendation. So that, we spend a lot of time talking to people about this kind of documentation because sometimes folks don't think of it that way. They don't consider their activities, their day-to-day activities, their other involvements as interesting or important, but they are, because it demonstrates to the court that you are involved. You're in the community, you're walking in the community, you're being held accountable by the community, which is different than, maybe you were involved with criminal behavior. The folks you were running with in those days might have been very different than the folks that you're associating with now. And we want to contrast your past with your present in order to establish why it's the right thing to do for you today. Next slide. All right, so record sealing, as I said before, this section, there's always been record sealing in California. There's always been ways to seal your record, but it was always very difficult to get to, very difficult to be granted, very difficult to prove that your particular matter should be sealed. This, in 2018, this new law was enacted, this new part of the record sealing statute, 851.91 of the Penal Code, says that it's mandatory to seal your arrest record if you were arrested and charged, but the case was dismissed without you ever having been convicted, or you were charged and found innocent at a trial. So let's talk about the first category. You were arrested and charged, but the case was dismissed without you being convicted. So oftentimes what happens with folks is they get arrested on one case, and it turns out that there were other cases that either were pending or that are filed at the same time. And then there's, in some plea bargain, the person agrees to plead to one case in exchange for a dismissal of whatever other case or cases might have been pending at the same time. Each of those cases that was dismissed is eligible to be sealed. And the sealing goes all the way back to the date of the arrest after a certain period of time. And the sealing means that it comes off of the record that's available to the public. Now, remember that criminal records are public records. So criminal cases, anyone can go to the courthouse and say, I want to review Joe Blow's file. In this case, I want to look at the file. And the court would have to give it to you, give it to the person asking for that file, because they are public record, okay? But once it's sealed, then it comes off of the public view completely. And so your typical employer, your Winco, your FoodMax, places like that are not going to be able to see it at all. And the same as if you were charged and found innocent at a trial, either by a court or by a jury. If that's what happened, then you can seal the fact that you were ever in court on that case. Next slide, please. All right, so you're not eligible to have your matter sealed if the case can still be charged against you. Sometimes a matter would be dismissed and without prejudice. What this means is at the point in time that it's being dismissed, maybe the district attorney didn't have the evidence that they needed to charge the person. So they're asking the court to, and they can't prosecute. So they're going to ask the court to dismiss the matter rather than be forced to go to trial, because then once a trial is held, and if the person is found innocent, they can never bring that charge against that person again. So if they dismiss it, they can still charge it at any time before what's called the statute of limitations has run. So the statute of limitations is the period of time that the district attorney has under the law to bring charges against a person. And it can be 2 years, it can be 3 years, it can be 5, it depends. Every charge is different. And so in order to determine the statute of limitations, you actually have to look at the statute of the particular charge that's in dispute. So if it can still be charged, then that case will not be eligible for sealing. In some charges, there is no statute of limitations. So murder, rape, some of the more serious crimes, there is no statute. So if they haven't prosecuted and it's been years, and you want to seal it, you can try that. We'd really have to come up with some interest of justice again. So why is it the right thing to do, even though the district attorney has, forever to bring this prosecution against you? Why should the court seal it? And I'm going to tell you, it will be very difficult to convince a court that on a case like a murder charge, that the statute of limitations should be overlooked. I'm sorry, that the court should not consider that the statute of limitations is wide open and go ahead and seal your case. It would be very difficult. If you intentionally evaded law enforcement to avoid prosecution, so you knew that they were looking for you, you ran away to Canada or Mexico or Europe, and that's why you avoided prosecution. And now you've got, now they have you, you come back and you say, I want to seal this because it's past the statute of limitations. Yeah, well, if you intentionally try to avoid being prosecuted, then that's not going to hold water. If the charge you want sealed is a domestic violence matter, or a child abuse matter, or an elder abuse case, and you have a history of these kinds of cases, then the court will likely deny you sealing. You're not eligible, okay? The court, but as in any of these, the court can consider whether granting you the sealing is in the interest of justice. Okay, next slide. So what are the benefits of record clearing? So a private employer, once this is granted, once your expungement or your sealing is granted, a private employer cannot ask you about or consider criminal history involving an arrest or detention that did not result in a conviction. Actually, that they can't ask you about it right now, whether it's been sealed or not. They cannot ask you about anything that did not result in a conviction. They cannot ask you about participation or referral to a diversion program. And here now, they cannot ask you anything about a case that was dismissed, sealed, expunged, or statutorily eradicated, so that some of those marijuana charges that are no longer crimes because the Proposition 64 did away with them, they cannot ask you about those arrests anymore. They cannot ask you about arrest, detention, diversion, adjudication. An adjudication is what they would in adult court would call either a trial or a plea. Adjudication is a court has made a finding about something being true or not proven in juvenile court. And a disposition is the sentence in juvenile court. And you cannot be asked about non-felony conviction for simple possession of marijuana that's over 2 years of age, 2 years or older, okay? Now, who can still ask you about these things? If you want to work for law enforcement or criminal justice agencies, Department of Justice, California or federal, you want to work for the prison system, you want to work for CHP, you want to be a parole officer or probation officer, anything related to law enforcement employment, they are going to be able to ask you, they're going to be able to see all these things, and they can even deny you employment because you have these things on your record, even if you go through the expungement process, and even if you seal your record on those matters that are eligible for that. If you want to work in healthcare facilities or with pharmacies, they're going to be able to see your entire record. Occupational licenses in California. If you want to work with something that requires you to be licensed or to have a certification by the state of California, those agencies, those boards that issue those licenses or certifications are going to be able to not only ask you about them, you're going to be expected to tell them that you've had these convictions and these arrests, even if they've been sealed, even if they've been expunged. And failure to disclose to these boards and these agencies will result in almost an automatic denial of licensure or certification, okay? Now, if it's been expunged or sealed, they have to take that into account. But if you don't disclose it, then they don't have to pay attention to that. So it's very important to understand which agency you're asking for licensing and understand their requirements, and so that you don't unintentionally put yourself at a disadvantage and face possible denial of being licensed, okay? If you want to work with vulnerable populations, elderly, children, with children, or with persons with disabilities. So if you want to work in a rehabilitation home, if you want to work with childcare, you want to work with a, you want to offer care to people who have disabilities, you're going to be expected to pass a background check. And so those folks will be able to see everything and will be able to ask you about everything, and also will be able to deny you employment based on your criminal history. Next slide. So here are the limitations. So, so this applies to convictions. What we're talking about here applies to convictions. So you were actually sentenced, now maybe the matter's been expunged. So expungement does not restore your right to possess a firearm. It does not protect against prosecution for illegal possession of a firearm. It doesn't prevent the conviction from being used in a subsequent prosecution. So that it can be used as an enhancement. It can be used as a prior felony conviction to increase the consequences in a new case. And it can be used to impeach you if you choose to testify on your own behalf. It doesn't prevent the use of these convictions under federal law. So if you pick up a federal case and you have a state case that might have been expunged or even reduced, the federal prosecutor can still use those crimes and treat them as felonies and treat them as matters that have not been expunged or sealed, expunged, to increase or to prosecute you and use those as prior convictions. And it will not protect you from immigration consequences. So if you have a crime on your record that could be used to attempt to deport you or to deny you continued status as a legal permanent resident, this will not necessarily protect you. It doesn't provide relief from registration under the Sex Offender Registration Act or from being listed on Megan's Law website. And it doesn't restore your driving privilege or prevent conviction from being used to suspend or revoke a driving privilege. So now that's important to understand, because there's folks with DUIs who get their matters expunged. If it's still within the time period where the DA can use it as a prior conviction, expungement isn't going to protect you from it being used as a prior. So if you have a DUI and then with, let's say, 8 years later, you pick up a second, then they're going to be able to use that first one to increase the consequences on the second one, including time in custody, including fines, including what kind of program you're going to have to complete in order to have your license reinstated. Next slide. So how to get help? There's in Fresno County Public Defender's Clean Slate Program, that's my program, is available to help you, but we can only help you with Fresno County convictions. If you have convictions in another county, along with convictions at Fresno, we can probably refer you to an agency or organization in that other county that can help you. So to get to us, you go online at Fresno County Public Defender's Office. You look for Clean Slate, you click on that, and you'll see online application. Fill out the application, it comes to us. We will do the research for your Fresno County convictions. You will not need a rap sheet for us. As long as it's a Fresno County case, we know where we can find it and we can figure out what's going on and what you might be eligible for. If you know that you don't have Fresno County convictions and you know that your convictions are somewhere else, you can contact Root and Rebound. They have a hotline at the number that you see on the screen. That hotline is open on Fridays, 9 to 5. And there's another place you can go to figure out other county resources. And that is, and I should have included it here, my apologies. It's called clearmyrecord.org. And you go in there and there's a direct link to public defender offices in other counties where you might be able to get help. So again, it's clearmyrecord.org. And that concludes my portion of this presentation. And I'm going to hand it over to Faride. Faride?
Hi, good morning, everybody. Thank you, Carmen, for reviewing all of that. I know this is a lot of information, and I think folks might be asking, why are we doing this? Why should we go through this process? Why should we go through the process of record cleaning? And so I'm here to talk about two big things that record cleaning can do for you, and that is occupational licensing and employment. So if I could get the next slide, please. And actually, before I get in here, I just want to reintroduce myself, Faride Perez. I'm currently a staff attorney at ACLU of Northern California. So my focus right now is primarily in policy work, but prior to coming to the ACLU, I worked with Root and Rebound, which was the organization that was mentioned earlier. And so I'm happy to answer questions about what kind of support that organization can give to you. But yeah, so let me just start by reviewing some of these benefits to record cleaning. So what is an occupational license? Anytime you're trying to get a job that requires some kind of training, a lot of the times you have to go through these agencies set up by the state of California to be able to just have permission to work in this profession, right? And so that's a lot of jobs. It's about 30% of all of California jobs require a license. And over 40 boards under the Department of Consumer Affairs, which amounts to about 1,770 different occupations. You can go to this website to look at all of those licenses. And so if you're thinking about, what career do I want to get into, it might be helpful to look at this and figure out if your conviction will be a problem or if you have to prepare. So some examples of that, if you're trying to go to nursing school, if you want to work as a barber even, or if you want to, there's so many different, like I said, 1,000 different licenses that you might need to go through this process for. And so again, if you check out this website, you can take a look at all of those licenses. And if you were really looking into a specific license, you could talk to Root and Rebound, and they can give you a little bit of an analysis as to how your conviction can affect you. And so a really kind of relevant and recent law is AB 2138. This was passed about, I'd say 2-3 years ago. And what this law did was it provided some limitations on what kind of convictions can be looked at when you're applying to these licenses. So prior to this law, everything that was on your record, no matter how old it was, could be considered when you're applying to licenses. And then prior to this law, there was also these what was called candor traps, right? And I think Carmen mentioned this a little bit earlier about your obligation to inform the board about what was on your conviction history. And so this, although you should still be very honest about all of the things that are on your record, this is not going to be a detriment to your application, but it is definitely a consideration. So if I could please get the next slide. Okay, so yeah, like I mentioned, AB 2138, it really did create some support for people that are applying to these licenses. And we're talking specifically these licenses under the Department of Consumer Affairs. Again, I'm not going to list all of those, but it's quite a bit. And so and also within the Department of Consumer Affairs, there is the Business and Profession Code 480 that has some exceptions about certain licenses that don't actually abide by this law. So what I mean is that I can't remember what those specific licenses are. I think they're related to financial types licensing, where there's certain convictions that might still be considered despite them being 7 years or older. I'm not going to go into those. Those are very limited. And so let me talk about like the majority of what these licenses look like. So you cannot deny a license at this point for any convictions that are older than 7 years. And again, there's always exceptions if there is a serious felony under Penal Code Section 1192.7C, the 290 registrations we were mentioning related to sex offenses, and certain felony financial crimes for these 6 select boards. So I think there's certain, like, for example, real estate is considered one of these financial licensing. And so certain financial crimes, like if you were convicted of fraud, might still be considered even though there were 7 years or older. So if you do get your record clean, however, even if you have a conviction that is, let's say, 3 years old, if you get that dismissed or what we're calling an expungement, those would not be considered. So that is the benefit there of getting your record clean, right? If you have a conviction that is more recent and you qualify for a dismissal, then you can get that cleaned up and the board will not look at your conviction when applying to a license. Convictions where a COR or pardon was received. Those are also convictions that are not considered. Now, we didn't really go into what a COR or a pardon is, but just shorthand, there are certain, after waiting about 7 to 10 years, depending on the conviction, you may be eligible to apply for what's called a certificate of rehabilitation or a pardon. And these are for convictions that led to prison terms primarily. If you have questions about your eligibility for this, again, you can call Root and Rebound and they can let you know if you qualify. Other things that are not seen by licensing boards: arrest, diversionary programs, deferred entry of judgment programs, infractions, citations, and juvenile adjudications. So many of these things are just, for example, if you got a ticket, those are likely not going to be considered. If you got an arrest, but it didn't lead to any conviction or sentencing or anything like that. If you were part of a diversion program, so for example, if you did drug court and you had to show up to court and report instead of serving jail or prison time, then that those types of programs that are not considered convictions cannot be considered. Now, let's say you have a conviction that is not dismissed and is recent. You may still be able to apply for this license. And however, you still have to go through this process with the Occupational Licensing Board that and where they have to explain to you that your conviction, how it is that it is substantially related to the occupation that you are applying to, right? And so I'll give you an example. So if you have a conviction for, let's say, a car theft, and you're now applying to a license to be a nurse, you can, the board has to explain to you how it is that your conviction as for car theft was related to your occupation as a nurse. And so arguably, of course, the board is going to make the argument that it is related, but in my opinion, it would not be related, right? Like, how is it that your profession as a nurse is gonna, I mean, there's no cars, right, related, there's nothing there that has a similarly situation that was resembling your conviction. And so that's the type of analysis that the board would begin with. And so what this law did is you're supposed to be able to get that analysis given to you. Okay, they must show you exactly how it is that your conviction is related and there's a substantial relationship with your occupations. And like I mentioned, the candor trap, we still want to be honest and upfront about what is on your record, but it is not a complete detriment if you happen to not mention it. And so, and this can happen many times when, you know, there's folks that sometimes don't know what is on their record. There might have been a charge in a random county that you were passing through one time, and then, you know, it didn't lead to anything, and it pops up when you're applying to a license. And so that's kind of what that's headed. All right, let me go to the next slide, please. All right, and so if you get to the point in which you get denied a license, you have a chance to appeal that decision. You can go to an administrative hearing, and what that is, it's like a mini court trial. It's not as formal as going to, let's say, criminal or civil court, but it is very much a serious consequence, right? We do want to take these things seriously, and there's ways to prepare for this. One of those major ways to prepare is to put together evidence of rehabilitation. And so this is very similar to the type of information that you would be providing in an expungement application or a dismissal application. So again, demonstrating to the court that whatever your conviction was, that was in the past, you have now witnesses, letters, certificates, anything that you can think of to put as an example of your progress, and to show the court that you will use this license for the purpose of employment responsibly, and you know, that it is something that you're progressing with and will be an addition to your life. Okay, and so if you go on this website, there's more information there about what types of evidence you can put together if you are representing yourself. Again, these processes can be really daunting, and you know, sometimes you need some support there. And there aren't very many attorneys that work on this type of hearing representation, but again, if you go to Root and Rebound, they can at least guide you through this process, and on occasion they do representation for free. There are also a couple other attorneys that are not free, but that they could refer you to. Next slide, please. Okay, so employment. So let's say you don't need a license to the job that you're applying to, and you just want to know, what is it that they can look at? I have a conviction, what can they look at? Well, most California employers, and this is both private and public, that have kind of less than 5 employees are not covered by this law. And so, and actually, let me go back. So AB 1008, this protects you from certain convictions that are older, from not being able to show up in a background check. And so, but there are some exceptions. So certain employers are not covered by this law. And those are usually like smaller organizations, smaller companies. So if it's less than 5 employees and they're not they're not going to be covered by this law. Carmen mentioned earlier, if you're applying to law enforcement, criminal justice employers, they will still be able to see your record. Where the law requires the employer to run a background check for a specific job, the employer may ask about the applicant's record up front. So very few exceptions here. If you're working in finance or other jobs that the government regulates, then they might be able to require a background check. However, for most jobs, when you're applying to a job, they cannot ask you about your conviction history. They cannot run a background check until they have offered you a job. Okay, I'm going to repeat that again. If you're applying to a job, if you see on an application where it says, do you have a conviction? That's illegal. They should not be asking you that. If you are in an interview and they ask you, do you have a conviction history? That's illegal. They're not supposed to do that. Now, you go through the interview process, you get an offer, but they say, we have to now run a background check. That's okay. Because at that point, they've offered you a job. And so the purpose of this law is, let's give people a chance to get hired before they get to the part where they ask you about your conviction. And at that point, they've already decided you're worthy of this employment, and it's a matter of just looking at your background check, right? So, all right, let me go to the next slide, please. Okay, so let's say they now, you get offered a job, they run the background check, and they're like, well, you have a conviction here. Is that enough to fire somebody or not offer them the job? No, that's not enough. They still now have to let you know how it is that this conviction is going to prevent you from doing the job, and they must give you an opportunity to provide evidence of rehabilitation. Okay, and so they have to, for example, consider how long ago this conviction occurred, whether it's directly related to the job, right? So this is similar to when you're applying to an occupational license. They must give you a notice. Okay, they must give you this notice in writing, and they have to let you know what is the conviction that they have a problem with, a copy of the record that they ran or the background check that they ran, and the date by which a response would be needed. And so this is really important because sometimes you might get a pre-adverse action notice, right? A notice that you're going to get, that they're considering your record and that it's a problem. And sometimes those records are wrong. So take the opportunity to ask for this paperwork. Ask about what it is that they're considering, and it's your right to do that. They must give you this notice. Now, you have a right to appeal this, but what's really important here is that you have 5 days from the receipt of this notice to respond. That doesn't necessarily mean you have to provide all the evidence within 5 days, but you have to at least say, hey, I'm interested in appealing this. I need some time to provide this evidence of rehabilitation. Once you do that within the 5 days, they must give you another at least 5 days to be able to present that evidence of rehabilitation. And these, again, are letters of reference, an explanation to what led to the conviction, proof of education, training, volunteering, work experience, all of the good things that you can show that proves that you are a good employee. And now if you then, after providing this, the employer decides to revoke the job offer, that must be done in writing. And so I'll say that many, in my experience, many times people see this notice and they give up and they say, well, I have a record, they're not going to give me this job, and that's it. In my experience, if you respond, the likelihood of you getting this job is actually pretty good. People don't expect for you to fight for this, for whatever job it is. They don't expect you to have this information prepared. And so it's always important to have like these things ready to go if you are applying to jobs, right? Like have a folder where you have these letters of recommendation, have all your, if you got good grades, like have your grades somewhere, right? Have something, have things prepared for when you're applying to these jobs in case this type of situation happens. Okay, next slide, please. Okay, so what if you go to a job and right on the application, they're asking you, do you have a conviction? Like I said earlier, that's legal, right? And so we know already that is a violation of AB 1008. For one, take a picture of it. Make sure you have all of this stuff. You know, if you're seeing these things, track it. And you have a right to file a complaint with the Department of Fair Employment and Housing. There are various ways in which an employer could violate this law in the process, right? It could violate it during the interview process, like I mentioned, during an application. It could just be a conversation where they ask you this. I mean, it comes about in so many different ways. And so, you know, if you have any doubt in your mind about this, you can file a complaint. It's very simple. It's like a form that you can go through online. You can even do it by the phone. And then what happens is that you get I think they call it an investigator assigned to this, who would then call you and ask you questions and then let you know whether or not the department will take your case. And so if they decide that they want to take your case, there's an attorney that's assigned to you, and then they will help you enforce, you know, go through this process and sue the employer. Okay, so again, all of these things are very highly dependent on your situation. You know, like I said, there's convictions. These, and when I'm talking about the convictions in the realm of employment, this is any conviction. So you don't need to get your record clean for this to apply to you. Any conviction that is dismissed cannot be seen, but anything older than 7 years can also not be seen here, right? And so I know this can be a little complicated sometimes because there's very many exceptions, but if you have any doubt in your mind, it's really important to fill out these complaints, because this is actually the way that you know, policy makers then take that information and decide whether or not there's a necessity to create a new law. And when people see that there are no complaints being made, they think and assume that there isn't a problem, right? That folks are following the law. And so we want to make sure that that is known if you are experiencing this. Okay, and next slide. Okay, so just some tips here. You know, there's this idea of evidence of rehabilitation, right? Or we've used that so many times in this conversation, as presentation. And, you know, it can be used for so many different things. We mentioned it in record cleaning and licensing and employment. And so, you know, think about all of these people in your life, your support system, your colleagues, your teachers, you know, friends, whoever it is that you're surrounding yourself with, and think about, you know, what these relationships could mean to demonstrate the fact that you have rehabilitated, right? And so, you know, try to gather that information and have it ready just in case, right? Certificates, volunteers, opportunities. You know, if you don't have that yet, you can begin to make that, right? It's something that could easily be built. And so there's a link there for more information on how to gather that evidence of rehabilitation. But you know, again, it's really important to have that stuff ready. I know we're running out of time, and I said we would have time for questions. So let me go through this really quickly here. So just very, you know, generally get comfortable talking about your story. When you apply for a dismissal, you're gonna, many times you're gonna have to put together a declaration. You have to know how to talk about your conviction history, how to talk about, you know, what it is that happened that led you to that situation. And that can be really hard because many times it could be the very first time you're talking about it, right? And so think about it a little bit and prepare yourself to be able to do that. And next slide, please. Okay. Again, look at your support systems, make this, you know, make those connections, get, you know, these organizations exist for a reason, right? We're doing this, we're participating in this conference for a reason, because we're here to support each other. And there are resources out there, and it's just about sharing that out. Here are some of those folks that are doing this work. And I can definitely say these folks are working very hard to make sure that anybody with a conviction history has opportunity. Resources, Public Defender's Office, Root and Rebound, California Central Legal Services, right? All of these are local organizations or statewide organizations that can support you. All right, next slide. All right, so that's it for me. I know I went through that a little quickly, but I know we have a few minutes. If you folks do have questions, I'm happy to answer anything about Root and Rebound, or if y'all have questions for Carmen. But thank you so much.